Okay.
Please tell us your name and roll number for this exam.
Sir, my name is DK Balkrishnan and my roll number is 5,79,000.
Okay. So we'll concentrate on your optional subjects. So let us start with crimes and tort.
Right, sir.
Tell me what you mean by tort and what are the ingredients of a tort.
Sir, tort is a civil wrong, and generally it is a civil action for unliquidated damages, which is not a breach of contract uh, or breach of trust. So this is the definition as given under Limitation Act. And these can also be told to be the ingredients. Basically, it's a civil wrong, and it's a civil action with unliquidated damages.
Okay. So what is the difference between strict liability and absolute liability?
Sir, in strict liability, there are exceptions in strict liability. Although the liability is strict, but there are certain exceptions to it. For example, be it act of God, or be it the party's own negligence in that matter. But in absolute liability, there are no defenses at all. And strict liability was the principle was enunciated in the case of Rylance versus Fletcher, whereas absolute liability is more of a subsequent development in comparison to strict liability, and that is the reason why we can see that whatever loopholes were left in the strict liability, they got covered in absolute liability.
Okay. What do you mean by proximate damage and remoteness of damage or remote damage?
Yes. Sir, if the damage that has been caused by a particular action, if it is proximate, or if there can be a reasonable foreseeableness to the damage caused and the action which caused it, so that can be called as proximate damage. Whereas remote damage is the damage caused by the particular action was not foreseeable, or there cannot be a proximate link towards it. So that is called as a remote damage.
Mm-hmm. Okay. So what do you mean by vicarious liability?
Vicarious liability is a liability that is imputed of someone's action. So vicarious in its literal sense means through someone. So if we see vicarious liability that way, so sir, for example, the liability of the actions of an agent can be imputed to that of a principal, or the liability of the servant can be imputed to that of a master. So basically, it is the liability of one's action being imputed to the other that can be known as vicarious liability.
Okay. So what are the punishments which are prescribed under the Indian Penal Code?
Sir, the punishments are enshrined in section 53 of IPC. So there are broadly there are 5 kinds of punishment that can be seen in section 53 of IPC. Capital punishment, imprisonment for life. Then we have imprisonment, which can be either rigorous or simple. Then attachment of property, and then fine.
Okay. So how is sedition dealt in the Indian Penal Code?
Sir, sedition is mentioned in section 124A of IPC. and it was initially in the first draft of IPC, it was not there. It was added via an amendment in the year of 1898. Sir, can I give the present position of sedition now?
Yes, you can.
Yes, sir. In a landmark Supreme Court order, which comprised of the former Chief Justice of India, Justice N.V. Ramana. So, in that particular case, it has been now said that there is uh, going to be a change on it.
Mhm.
The center is reconsidering its position towards section 124A of IPC.
Okay. So, what is the difference between fraud and criminal breach of trust?
Sir, fraud is, sir, by fraud, are you referring to cheating, sir?
Under IPC, fraud, what
Yes.
is the difference between fraud and criminal breach of trust?
Yes. Sir, in criminal breach of trust, generally we can see that there is an entrustment of a property, be it movable or be it immovable. Whereas in fraud, there is no particular entrustment or a creation of a contractual relationship or a trust relationship to the other party or to the accused. The second difference that we can see is generally there is no inducement when it comes to criminal breach of trust, whereas in fraud there is an inducement uh, of there is a fraudulent inducement of the particular person, maybe to deliver the property or maybe to cause a destruction or cause wrongful harm to the particular person.
Okay. So, what do you mean by affray? And what is the penal provision? What are the penal provisions for affray?
Sir, section 159 of IPC entails the provision pertaining to affray. So the ingredients of affray are if two people are fighting in a public place and which causes disturbance to the public peace. So that can be termed as affray. That is known as affray. So those people are punishable under affray.
And what is the punishment? What are the penal provisions?
Sir, I am not 100% sure, sir, but can I give an attempt? Sir, it is basically a non-cognizable offense, and the imprisonment is of 1 month. 1 month, simple imprisonment. So, from what I can recollect, sir.
Okay, just go through that part again. Okay. What are the types of aggravated theft that is dealt under IPC?
Yes. Sir, section 382. So, section 380, section 381, section 382. These are the sections which deal with aggravated form of theft. So, if a theft is accompanied with death or grievous hurt, or if a theft is committed by the clerk, so these are the aggravated forms of theft that is entailed in IPC.
Okay. Now let us come to jurisprudence and constitution. So, what is natural justice? What are the principles of natural justice?
Sir, the principles of natural justice are audi alteram partem and nemo judex causa sua.
Okay, which means?
Sir, audi alteram partem is basically no person should be condemned unheard, whereas nemo judex causa sua is that a person cannot be judged in his own cause. And audi alteram partem is also an essential principle of Article 14 of Indian Constitution. So we can see that although it's a principle of natural justice, it has been well embodied in the Article 14 of Indian Constitution.
Okay. What are the elements of Dicey's rule of law?
Sir, no one is supreme. No, everyone is equal in the eyes of law. Sir, there are three principles. Sir, right now I am able to recollect only one, sir. Sorry.
Okay. So, can you tell me the power equation between directive principle of state policy and fundamental rights?
Yes. Sir, if I am allowed, sir, can I take this with the help of a case? Can I explain this with the help of a case law?
Yes.
Sir, yes. Sir, in Minerva Mills versus Union of India, the case laws can be seen from Champaka Dorai Rajan versus State of Madras. From there, we can see the development till Minerva Mills versus Union of India. So in Minerva Mills versus Union of India, the Supreme Court has said that DPSP and principles of natural justice, there is supposed, DPSP and fundamental rights, there is supposed to be a harmonious construction between both of these provisions, and they are supposed to be complementary and supplementary to each other. But in case there is no other possible interpretation, and if DPSP, if a law under DPSP contradicts fundamental rights, then fundamental rights shall gain precedence over directive principles of state policy.
Okay. Is there any exception to it?
Sir, the principle where fundamental rights gains precedence over directive principles of state policy, to that principle an exception?
Yes.
Sir, so generally there is supposed to be harmonious construction, like that is the general case, whereas these are supposed to be complementary and supplementary to each other. The court will try to strike an interpretation where both of these can coexist together. But in case if it does not happen, then this rule shall prevail, wherein fundamental rights shall prevail over directive principles of state policy.
Okay. There are two directive principles of state policy which, okay, generally can prevail over Article 14 and Article 19. Can you tell me which are these two directive principles?
Article 14 and Article 19. Sir, I am unable to recollect
39 B and C. Okay, 39 B and C, that comes under exceptions to fundamental rights under 31 C. Okay, so so savings in cases of laws giving effect to certain directive principle of state policy. So if any law is made to give effect to 39 B and C, so they won't be violative of 14 and 19. Okay.
Okay. Thank you, sir.
Okay, fine. What is the difference between procedure established by law and due process of law? And which of these are we following now?
Sir, which of these are the following?
Are we following? India is following now.
Okay. Sir, initially in the draft of Indian Constitution, it was basically procedure established by law, and which was taken by the Japanese Constitution, borrowed by the Japanese Constitution. But later on, we can see in Menka Gandhi versus Union of India, the Supreme Court has interpreted procedure established by law as due process established by law, and this particular principle has been borrowed by US. So now we can see that the principle that is now followed is due process established by law. Due process established by initially procedure established by law was that life and liberty. This is with respect to Article 21 of Indian Constitution, that life and liberty of a particular person could be deprived by procedure established by law. So the only required mandate was that the law has to be duly established, the procedure has to be duly established by law. But now it is not the same. The procedure has to be not just to be established by law, but it has to be fair and reasonable. So Menka Gandhi, in Menka Gandhi versus Union of India, this particular conclusion has been drawn by the golden triangle of Article 14, 19, and 21, where the law which deprives a person of his life or liberty should not only be merely a procedure established by law, but should be fair and reasonable.
Your other optional is personal law, or property law.
Sir, in the property law.
Okay. So, what are the types of properties that cannot be transferred according to Transfer of Property Act?
Sir, the list of type of properties that cannot be transferred are enshrined under Section 6 of the Transfer Property Act. So the first clause being spes successionis, which is basically if there is an apparent, if there is an heir apparent, so he cannot transfer that particular thing. And then there is DD under Section 6. So maintenance, it cannot be transferred. Then public office, stipends of a public officer, that cannot be transferred. So the list is given in Section 6, but so this are the following things that I am able to recollect right now.
Okay. What do you mean by lease pendants?
Sir, lease pendants, it means that during the pending of litigation, like this is the literal meaning of lease pendants. The principle is enshrined in Section 52 of Transfer of Property Act. So basically, if during the pending litigation, if a property is directly or is related to the suit, or it is the subject matter of the litigation, then during the litigation or during the pendency of the litigation, if the suit is transferred to someone else, so the particular transferee will be subjected to the outcome of the result of the pending litigation or the pending suit. So this is list pendants.
Okay. What do you mean by mean profit?
Sir, mean profit is the principle can be seen in Section 2, subsection 12 of the Code of Civil Procedure. And basically, if it's in an immovable property, if it is not in possession with the claimant, and it is in unlawful possession of someone else, so the profits that could be reasonably or diligently drawn from that particular property, if that can be claimed by the person who is not in possession, in a litigation in addition to the possession of the property. So that is mean profits.
Okay. So, what do you mean by adverse possession?
Sir, adverse possession, it means the concept or the principle underlying adverse possession is also it is the object of Limitation Act, that the law, it does not favor the one who is relaxed or the one who is lazy or the one who is slumber. It only favors the one who is active pertaining to his or her rights. So adverse possession is basically that if someone has perfected the title of a particular property by adverse possession for a period of 12 years, he or she can be said to be in adverse possession. The particular or the relevant provisions pertaining to adverse possession is Section 27 of Limitation Act, read with Article 64 and 65 of the Limitation Act. Sir, can I give a landmark case law on this particular point?
Yes, okay.
Sir, Grewal case. It is Grewal case, Grewal versus Manjeet Kaur. This is a 2019 Supreme Court case. So here the Supreme Court has told that reading Section 27 along with Article 65 of Limitation Act, the person in adverse possession can also file a suit against the owner, because he or she now has perfected the title. So he or she can also file a suit against the owner if his or her possession is being disturbed in any manner. So it is against the rest of the world anyways, but it also lies against the owner an action.
Okay, fine. Fine then that will be the end of the interview.
Yes.
So overall, okay, you are able to answer most questions and content was also fun. Okay.
Yes, sir.
Okay.
Sir.